So dear participants here on site and also dear online participants, I very much welcome you to the lecture of today on freedom of environmental information. Today, we already organized the 6th lecture of the lecture series, Strengthening EU Environmental Law, Legal Perspectives on Greening Europe. In fact, it's the opening lecture of our new academic year. And I very much welcome the new students here on site. I'm very happy to see about 30 students and even more here in the Statenzaal. The lecture of today will be a special one since for the first time, the lecture will be delivered by 2 speakers, both located in Scotland. First, I'm very honored that Professor Colin Reid has accepted this invitation. Professor Reid is Emeritus Professor of Environmental Law at the University of Dundee. And I'm very happy, Colin, that you have accepted to lecture even while you are retired. Professor Reid will be joined by Dr. Sean Whittaker, who has obtained a PhD in environmental law and has published the book, The Right of Access to Environmental Information. And this is also the topic of the lecture of today. So without further ado, I would like to give the floor to our lecturers. So dear Sean, dear Colin, I invite you to take the floor.
Thank you very much. Good afternoon, and we're sorry that we can't join you in the Netherlands. So, as Marianne has said, I'm Colin Reid, joined by my colleague Sean Whittaker, and the idea is that I will talk first, giving something of a background and introduction to freedom of environmental information, and then Sean will follow, speaking about some of the challenges in dealing with environmental information based largely on findings from a research project we've done studying the actual use of the right to access environmental information in Scotland. So what you'll see is me to begin with, and then Sean. We're easily told apart, as you can see from the photographs. So the right of access to environmental information. What is it? What's it about? What is going on? Well, it is a right for individuals to be given access to information held by the state about the environment. And obviously that immediately raises some questions of scope and definition. We have to think about what is environmental information and what is the state for these purposes. And both of these can be challenging, controversial, contested issues in various ways. In terms of what counts as environmental information, we find that the law provides a very broad definition to this. It refers to the state of the environment, that's basic scientific data on air quality, water quality, biodiversity, and so on, factors affecting the environment, and plans and policies that will affect the environment. And the various bodies involved in dealing with access to environmental information have consistently given a broad definition to this. So things that affect the environment can be very broadly defined. So the terms of a contract for a major infrastructure project can count as environmental information. And one of the early cases in Scotland, a rather odd one, involved the loan of giant pandas from China to Edinburgh Zoo, although the information, a lot of the discussion was about the international relations, the political diplomatic relations side of things, because at the core was the transfer of a protected and endangered species. The information surrounding that was all held to be environmental information. So it's to do with environmental information that has this broad, this wide definition. It's information held by the state, but one of the challenges here is that the boundaries of what are the state are constantly changing, have changed a lot since the legal framework in this area started a few decades ago. So it's not just information actually held by the state, it's also information held by private companies that are performing environmental functions for the state. So that in relation to England, for example, the water companies, companies that provide water supply, deal with sewerage and drainage. They are technically private companies, but because they are performing functions for the state, they are given legal rights to exercise those functions. They are covered by the rules on access to environmental information. So the individual has a right to information held by the state about the environment. And the right of access to environmental information has two elements. The first is the proactive disclosure of environmental information. There is an obligation on the state to make environmental information available automatically, not relying on requests, simply to provide information to put it in the public domain. And especially nowadays, in the age of the internet, this is something that happens very widely. One of the challenges we found in our research was that because people nowadays expect information to be available, it's simply business as usual. People don't think of the fact they're seeing environmental information. They don't see that as the exercise of a specific legal right, as something they're entitled to. It's just what they expect. The other side of the right of access is the disclosure of environmental information on request, that where information is not already in the public domain, individuals have the right to request information from the state body. There's an obligation on the state body to make that information available, subject to a number of exceptions we'll come to later. So you've got this two elements of the right of access to environmental information: proactive disclosure and disclosure on request. And the background to this is the joining together of two strands of thinking in relation to information. One is the general benefits of making information available, something that's been part of moves towards freedom of information, transparency, disclosure across the public sector in past decades. Now, in Sweden, the first laws on access to freedom of information go back to the 1770s, but it's really in the past few decades that around the world, government structures have accepted the need to be more transparent, to provide access to information. And there are a number of justifications for this. If you look in the literature, you look at what governments say when they're introducing freedom of information laws, when you look at what campaigners say wanting to expand, to extend freedom of information, a number of key elements keep coming up. The idea is to increase the openness and transparency of government, which in turn should increase the accountability of government because people can see what's going on, question and challenge it. It improves the quality of government decision-making, partly because it's being done in the open, that government has somebody looking over their shoulder, also because it allows people to provide more information into the process because they can see what's happening, they have the chance to make comments. Because what's happening in government is more transparent, it should improve public understanding of government. They understand what the government is doing, why it's doing it. You're increasing public trust in government because things are not happening behind closed doors. People can see the background information, some of the reasoning in government decisions. It increases trust. And all these things help to increase public participation in government. There's more engagement, greater public participation in what's going on. So these are the arguments that apply. These are the things that operate in relation to access to information, freedom of information more generally. But access to environmental information comes from a slightly different position, an overlapping strand of thinking, which links very clearly the connection between environmental information and public participation. In the development of environmental rights, the enhancement of environmental governance in recent decades, a key element has been public participation. As we'll see, the Rio Declaration made clear that public participation is an important element in environmental governance. And that ties access to information with other elements of what you can broadly call environmental democracy, typified in what became the Aarhus Convention, which has three strands of it to it. One of which is providing the public with information, That information then allows the public to participate in environmental decision-making. And the third strand is to make sure that there's access to environmental justice so that the rights of information participation are protected. But all of this is driven by a purpose, typified in the Aarhus Convention, that individuals have a moral duty to protect and enhance the environment. These rights have been given not for the general transparency arguments that apply to wider freedom of information. They have been given specifically to allow individuals, citizens, to protect and enhance the environment. That general background has led to a number of very concrete legal provisions, legal measures that have been introduced at the international, the European Union, and the domestic law levels. So, as I said, the Rio Declaration in 1992 is perhaps one of the key starting points in this area, where Principle 10 of the Rio Declaration declares that environmental issues are best handled with the participation of all concerned, fleshing that out by referring to access to information. That was then followed up by the Aarhus Convention, the Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters, agreed in 1998, that gives a lot more detail to how you actually provide this participation, this access to information. And the Aarhus Convention now has 47 parties, all of them in Europe or Central Asia, the former Soviet Union, but with one exception, because Guinea-Bissau has now ratified the convention. So it's open to countries around the world, and now for the first time spreading beyond Europe. While discussions were going on towards the Rio Declaration, the European Union was already taking steps towards access to environmental information. It was in 1990 that the EU first produced a directive on freedom of access to information on the environment, requiring member states to make sure that their citizens had right of access to information. That was followed up in 2003 by a revised directive to take effect, to implement, to give full effect to the details of the Aarhus Convention, and a further regulation in 2006 applying the provisions of the Aarhus Convention in certain contexts. So that EU law then had to be implemented in domestic law. In the UK, when we were still a member, that came in the form of the Environmental Information Regulations 2004 and the Environmental Information Scotland Regulations 2004. And from the limited research we've been able to do, we gather that in the Netherlands, it's the Open Government Act 2022 that nowadays is the key regulating feature. So across the European Union, and those of us who sadly have left, you have laws that reflect the EU measures, which in turn reflect the Aarhus Convention. So you have in the domestic law, EU law, obligations, legal obligations that reflect the convention and what is required there. So first of all, there are the measures on the proactive disclosure of information. So the state has an overarching duty to make sure it has relevant information and updates it so that it can carry out its functions properly. And states are then under an obligation to maintain a system to make sure that environmental information is made available to the public. Now, although it talks about a system, certainly in the UK, I suspect in most other countries, it's actually a very fragmented picture. What counts is that the information is out there rather than being in a single comprehensive, coherent, nicely organized system. So you've got this obligation on public authorities to make sure that they're collecting environmental information and making it available, with more specific obligations where there's an environmental emergency, where there's an immediate threat to human health or the health of the environment, where you may have an overlap with European Convention on Human Rights obligations in relation to protecting people's health. And in practice, as I say, the proactive disclosure occurs in many different ways. Nowadays, huge amount of stuff is made available electronically through websites and so on. I'm old enough to remember the days when public access to information meant having to visit the government office and they'd take a big file off the shelf and you'd sit at a desk or at the counter in the office and flick through it to see. Nowadays, so much information made available through websites, but it covers other things as well. Sometimes there are still paper registers of things. It even covers things like the notice boards that you have to have at bathing waters, reporting on the quality of the bathing water, the recent monitoring standards. So there's this obligation to make information available in many ways, and it's so much part of our expectations today that most people using this don't think of it as the exercise of a specific legal right to information. The other obligation is to provide information on request. So members of the public are able to request information that is not available otherwise. And the Aarhus Convention, through the EU, the domestic law, imposes very minimal obligations on members of the public seeking to request information. The requests can take any form: an email, a letter, a telephone call, calling in person, unlike many freedom of information regimes, which require you to make a request in writing, subject to various formal procedure requirements. Here, it's a very loose, a very flexible situation that applies. There's no need for the individual to specify why they want the information. You're just entitled to have it. Obviously, you must give enough information, must be specific enough to allow the authority to identify the information that's being asked for. But if there's uncertainty, if there's doubt, there's an obligation on the authority to offer assistance and advice to the requester. So if they don't understand what's being asked for, they can't understand what information is actually being looked for, they're meant to help the individual to refine the request, maybe to direct it to somebody else. And once a request has been received, the state must make the requested information available, subject to a few exceptions I'll speak about in a moment. They have to do this in the form requested. So if you've asked for information in particular electronically, it has to be provided electronically, or in paper, provided in paper. They're obliged to provide the information as soon as possible, or at the latest within 1 month. But the state is entitled to charge for the information, but it can only be a reasonable charge. So there are limits on what can be charged for the information that's sought. But obviously, a crucial area is going to be the exceptions. The state is not going to be happy always providing information. So the questions are, when can information be refused? When is the state entitled to refuse to disclose the information? Well, there are a number of exceptions provided in the right that can be grouped in two broad categories. The first are general exceptions that apply across the board. When you make a request, the state doesn't have to provide the information. If it doesn't hold it. That's an obvious thing. They don't have the information. They can't make it available. Although remember, there is a general obligation under the Aarhus Convention, under the law, for the state should have all the information it needs. And sometimes that's a bit problematical. There's an exception for information that's in the course of completion, where the authority is producing a report, you're not entitled to see drafts on the way through, and the authority is entitled to refuse to disclose the information if the request is manifestly unreasonable. If somebody's asking for huge amounts of information, if they're back every 2 weeks asking for updates on exactly the same information, if it's available in other sources and so on. So are those sort of general exceptions. There's also then a number of exceptions designed to protect specific interests. And as usual in freedom of information requirements, there are exceptions for things to do with international relations, national security. Commercial confidentiality can be very problematic in environmental areas where releasing details of pollution can tell commercial rivals something about the processes that are going on inside a factory. And there's also an exception for the safety of the environment. So you're entitled not to disclose, for example, the location of endangered plants, which would be vulnerable to people stealing them or taking them for other reasons. But in relation to these exceptions, where where you're applying one of the interest-based exceptions, one of the ones where you're balancing interests like security or environmental protection against other things, the balance is tipped firmly in favor of disclosing the information. So it's said in the law that the exceptions are to be interpreted in a restrictive way. They must always take account of the public interest in disclosing. So the default position is that the information should be disclosed. And when you're talking about emissions, so the state of the environment, rather than the policies or other things in the background, there's a stricter test to justify refusal. The grounds on refusing to disclose are limited. So the obligation is to disclose the information. The expectation is that it will be disclosed. There are some exceptions, but the attempt is always to try and tip the balance in favor of disclosure. And if the state doesn't provide the information, it must provide the reasons why it's not providing the information, and it must give detail of how their decision can be appealed. And within each state, there has to be an appeal redress mechanism so these decisions can be challenged. So from both general trends towards wider freedom of information and the specific environmental obligations, you have this convergence that's developed this right of access to environmental information, broadly defined information held by the state, broadly defined access provided both through the proactive disclosure by the state and the ability of individuals to request information that the state is holding. So that, I hope, gives a broad general overview of what we're talking about here. I'm now going to pass over to Sean, who's going to talk about some of the challenges in applying this. Thank you.
Thank you very much, Colin. So as Colin was just saying, the next half of our presentation is primarily focused on discussing the challenges in implementing the right of access to environmental information in the European Union. And just to kind of clarify or expand a bit more on this, implementation traditionally focuses on how the practicalities of actually implementing the right of access to environmental information. But in practice, the actual procedures are kind of well established at this stage. Rather, the difficulties and challenges facing the European Union is more focused on the extent to which the right of access to environmental information actually succeeds in achieving its goals. And that's primarily what our discussion here is going to be focused on. Our findings on this question have arose from our project titled Uncovering the Environment, the Use of Public Access to Environmental Information, which was funded by the Economic and Social Research Council. The project was aimed at investigating the use of information disclosed under a right of access to environmental information regime, focusing both not just on what's being done with it, but also who's actually asking for the information and what are their motivations. Now, our analysis has been underpinned by a doctrinal study of various court cases, of decisions of the Information Commissioner in either withholding or disclosing environmental information, as well as the gathering of empirical evidence through surveys and interviews with users, public authorities, and the Office of the Scottish Information Commissioner. Now, one elephant in the room that we should probably discuss is that our project was primarily focused on, and in fact wholly focused on, users and public authorities based in Scotland. However, because the right of access to environmental information has been implemented fairly similarly across the EU, including the UK when it was still part of the EU, our findings here are still applicable to other states within the European Union. And if that hasn't done quite enough to convince you, do please get in touch with us. We'd love to help you conduct your own empirical analysis on how the right is being used in practice in other EU states as well. Now, one of the key challenges faced by the EU, in particular with the implementation of Directive 2003/4/EC, is that a lot of it and a lot of the right of access to environmental information discussion is based on a series of underpinning assumptions about how the right actually operates. Now, that does make sense if you consider kind of the chronology of the creation of the directive. First of all, prior to the EU directive, the current EU directive, is the Aarhus Convention, which came from the Rio Declaration, which was which look towards Directive 90/313 EEC on access to environment information. So it's kind of been built on a series of underpinning assumptions about a lot about how the right actually operates and its purpose. One of the first critical assumptions which underpins the right is that all users are kind of viewed as the same, or at least broadly equivalent. This kind of comes to account in a variety of ways. One of the first key ways is this presumption that all users are broadly equal or equally capable of utilizing the right of access to environmental information. That every user has the expertise to ask for information or to find the information, to articulate what they're looking for, and then once it's disclosed, to actually understand the information which has been given to them. Now, both the Aarhus Convention and the EU directive, there is a notable exception, such as the duty to provide advice and assistance to users. However, even that is all kind of tied up in the directive's applicant blind process, where you aren't obliged to give an identity, like a name or address, to explain who you are and your kind of level of expertise. And even the advice given to users is based primarily on the discretion of the public authority in question. So again, that's not kind of a perfect way to kind of handle this broad assumption. Secondly, there's also a presumption that all users are driven by environmental motives. Both the EU directive and the Aarhus Convention operates under the assumption that individuals are getting environmental information in order to fulfill their duty to protect and enhance the environment, either through actively participating in environmental decision-making procedures, as per the second pillar of the Aarhus Convention, or by just using the information to hold the state to account. It's then presumed that this access to information will lead to a better and healthier environment. But of course, as you may have guessed from the setup of this slide, that is just not the case in practice. In fact, users really do illustrate a kaleidoscope of different levels of expertise, knowledge, motives, and even things like location as well. One of our most striking findings from the project is that there's not actually, as implied by the directive, a single body of similar individuals utilizing their right. In fact, kind of the two biggest groups kind of subdivided are professional users, individuals who access environmental information as part of their job. So people like journalists and consultants, planning officers, or planners, I should say, and personal users, individuals who are just regularly living their lives, who just may have an interest in particular environmental matters. And even with these two groups, there is some overlap between them. For example, if someone is a retired consultant, which group would they fall into? As a interesting and notable aside, we also identified there's actually quite a thriving activity of state bodies actually using access to environmental information rights to get information from other public authorities. Again, not really the intended use of the right, but still quite interesting to note as kind of a subversion of the assumptions that underpin the right in practice. Now, in terms of actually how individuals engage with environmental information regimes, there's a clear distinction here between the level of expertise and knowledge of professional users and of personal users. Professional users, by being trained, by being university educated, generally speaking, and by having the skills required to represent someone on a professional basis, are much more effective at formulating questions, about being confident enough to actually challenge authorities when they refuse to disclose information, and are just much more effective at actually getting information, understanding what's coming out of it. Conversely, personal users, while they may be equally, if not more, motivated to actually get this information, broadly speaking, they have a lot more challenges in actually articulating what they want. And even when they get the information, they have some difficulties understanding what's actually been disclosed to them. This point about understanding disclosed environmental information is actually fundamentally important for the EU. On the one hand, if individuals don't actually understand what's being given to them, then there's no way that they're going to be able to actually contribute to protecting and enhancing the environment. But on the other side, for public authorities, when a user gets information they don't understand, what then happens is they then send a further request. This then further burdens the public authority with more administrative procedures to follow, more work to do, and can actually clog up and take away valuable resources, which can be spent on other activities. The second point of distinction relates to the motives driving both professional and personal users. Broadly speaking, because professional users are acting as intermediaries for their customers, they don't actually have motivations in of themselves beyond economic. Rather, how their information is being used is purely being driven by the intentions of their customers. And that's quite fundamentally important, because most customers who are hiring the services of experts consultants aren't really driven by environmental motives. As a result, then, we kind of have to look towards personal users with the hope that they actually are driven by environmental motives. But again, even here, personal users, broadly by and large, only have really a subsidiary interest in the environment. Rather, they're more driven by personal interests. Why is this landfill site being sited near my property? What's happening with the local bugs in my area? They don't really have a broader concern for the environment and its quality. Rather, they're more driven and concerned by how it affects them personally. This then actually leads on to our second finding from the project. Beyond who actually is getting the information, how is this information actually used? Now, you remember from Colin Reid's half of the presentation that the primary aim as per the Aarhus Convention, primary aim of the right as per the Aarhus Convention, is that individuals are getting this information in order to participate in environmental decision-making procedures. This then leads to better quality decisions, thus leading to a healthier and better protected environment. But in practice, this aspirational dream does not really come about. In fact, the most visible and commonly referred to use of disclosed environmental information, at least in Scotland, was the challenging of decisions made by public authorities. In other words, decisions which have already been made, some of the decisions were being challenged, which also had a positive impact on the environment, was against the interests of the individual who was kind of nearby the area. Now, that is not to say that there are not other uses beyond challenge decisions or even participation. One critical user that we interviewed actually was asking about bats in Edinburgh and the siting of trees in order to kind of protect those bat habitats. So, very much a primarily environmental altruistic concern. But again, that was a real minority of users. The majority of users and uses are not driven by environmental altruism. And as a result, it's questionable the extent to which these uses actually have a positive impact on the environment. Moving on, even where users of environmental information and the right were actually seeking to participate in environmental decision-making procedures, people were dissatisfied with this. The common expression was that they didn't get the outcome they wanted. And again, there's a variety of reasons for this. On the one hand, the Aarhus Convention doesn't allow individuals access to information in order to dictate the outcome of a decision. They only have the right to participate, to try and influence it, to have their voice heard. But users don't see it that way. Users very much see the right as, I've got the information, I can now get what I want, whether or not that's environmentally beneficial or otherwise. This can lead not just to broad dissatisfaction with these participatory processes, but can also have dissatisfaction with the right of access to environmental information itself. Indeed, even where there are users who have the environment's best interests at heart, this definition of best interest or what's best for the environment can differ between different people. Two users equally driven by positive environmentally altruistic motives may have different views of what a good decision would look like. And if these views are contrasting with one another, then in terms of a participatory process, it becomes impossible to satisfy all users. Someone's going to be upset, and as a result, someone's going to be dissatisfied with how their rights have actually been realized in practice. All this kind of brings us to what I would call, and hopefully Colin agrees with me at this point, a slightly uncomfortable conclusion. The whole point of the right of access to environmental information is that it's meant to protect the environment. But the environment itself doesn't actually really play much of a role in shaping domestic environmental information regimes or even the EU level environmental information regimes. Yes, information can be withheld on the basis of trying to protect the environment, but beyond that, the right of access to environmental information and the EU directive is presuming that by disclosing information, people are going to be using it to help the environment, an assumption which is not borne out in practice and may in fact have negative impacts on the environment. In this way then, the right of access to environmental information, although being viewed as a way of protecting the environment, is really just anthropocentric. It's human-centered. It only really cares about humanity, and the environment only plays a factor in that to the extent that it will actually impact upon humanity. It may be an idea and it may be necessary for the EU in the future to place greater emphasis on the environment within the EU directive and within the EU states' domestic implementations of this. One potential way of doing this, and this is kind of a idea stolen from the US, is that a greater emphasis could be placed on the motives of users who are seeking the information. And there may be preferential treatment given to those who are proven or have been able to demonstrate a care for the environment. So this will then hopefully lead to information being disclosed and actions being taken, which will actually better help protect and enhance the environment itself. These last 2 points on this slide and the following 2 slides actually now reflect some trends in environmental governance and the intersection between this governance and the right of access to environmental information. Now, as Colin said at the beginning of this lecture, the Aarhus Convention and the EU directive, the scope of it is focused on the state, public authorities, and in the kind of fuzzy nature of how you define public authorities, private bodies performing public functions. However, with the increasing trend of privatization, in other words, when private services are performing public functions, there becomes a set of competing interests with regards to the ability or the obligation to disclose environmental information. On the one hand, you want these companies who are performing public services to be forced to disclose information on the environment that it holds. The reason for that is a broader sense of transparency, a broader sense of accountability, and to make sure the private company is not taking actions in performing a public service which actually harm the environment. Conversely, though, there's actually a desire on the part of states for promoting small businesses to get involved in the delivery of public services. There's a kind of a competing economic interest, not just in terms of efficiency, but rather also to help uplift smaller businesses to make them more competitive. And indeed, we're facing this in Scotland at the moment with our reforms to our own Freedom of Information Act in Scotland. Another perspective on this idea of privatisation is the fact that private companies, despite being the bodies which kind of have the most negative impact on the environment, are wholly excluded from the scope of the EU directive and the Aarhus Convention. Indeed, both instruments and their domestic implementations adopt what's called a market liberal model. So it kind of, in a sense, prioritizes the commercial interests of private bodies as being separate from the state. And in practice, and with the current development in environmental, social, and governance laws, where there is a greater emphasis on companies acting on, not on behalf of the environment, but acting for the benefit of the environment, becoming more open and transparent in order to help improve the quality and our way of addressing climate change. There's a broader question as to whether this distinction between purely private bodies and private bodies performing public functions is still justified. Noting the substantial impact of private bodies, the EU may wish to consider actually incorporating them into the Directive 2003/4/EC as bodies which are subject to and must disclose environmental information. This idea is not so crazy. Other jurisdictions, such as South Africa, have done this, and it has probably led to a much more transparent and accountable environmental governance structure. Secondly, and finally for this presentation, we also have to discuss the Aarhus Convention Compliance Committee, or the ACC for short. Now, the ACCC was established under Article 15 of the Aarhus Convention and was created through Decision I-7 of the conventions between the parties. The ACCC essentially acts as a non-judicial, advisory, and non-adversarial body which hears alleged breaches of the Aarhus Convention from either party states or members of the public, most commonly members of the public, and then issues decisions which seek to help states become compliant again with the Aarhus Convention. Now, these decisions are non-binding because, as we've just discussed, it is a non-judicial body. But in the context of the right of access to environmental information, most states do comply with the decisions of the ACCC, leading to a much improved environmental information regime within member states. Well, I say member states, but the EU is also a party to the convention. So I should say parties to the convention. This has a whole range of strengths, but also a few potential weaknesses for how we guarantee and implement the right of access to environmental information in the EU and EU member states. For one thing, the procedures of the Aarhus Convention Compliance Committee are designed to be accessible, similar to the procedures guaranteeing the right of access to environmental information. It's meant to be free and available to all. And as a result of this, not only can anyone actually submit a complaint to the Aarhus Convention Compliance Committee, which is a novelty for majority of international compliance mechanisms, but there's no requirement to be represented by a legally trained professional when making your case to the Compliance Committee. There are, however, a few issues with this accessibility. One key issue is that because there are so many cases coming to the Compliance Committee, and because the Compliance Committee itself is quite small, it can take quite a long time for the ACCC to issue a decision notice to help enforce the convention, to enforce information rights, as well as improve the implementation of the convention and the directive at the member state level. Finally, because the ACCC is non-judicial in nature, there's a broader question as to, well, what happens when a state or a party chooses not to comply? In the context of Article 9 of the Access to Justice provisions, this has happened twice, most famously with the European Union in the ACCC communication in 2008, number 32. And this is fundamentally problematic in terms of actually enforcing the convention. Because if states and parties such as the EU decide not to accept the decisions and recommendations of the Compliance Committee, then its authority to issue these decisions reduces. It makes it much less effective at actually implementing the right at a practical level in party states, which in turn will reduce the ability of us as members of the public to hold states to account, to hold public authorities to account, and make sure that they're doing the correct actions for the environment. So, to conclude all of this, the right of access to environmental information, despite what the assumptions it's built upon suggest, is not a singular right with a singular aim. Rather, the right encapsulates a complex network of aims, procedural rights, and implicit assumptions, which sometimes, and honestly more often or not, go against the foundational underpinnings of the right itself. This contrast between how the right is assumed to work and how it actually works raises a whole range of challenges regarding to the implementation of the right at the EU, as well as how we actually effectively meet the aims of the right of access to environmental information. However, despite me being so negative about the right this entire time, I do want to kind of end on a positive note. The right of access to environmental information is not just a flash in the pan right, which has kind of outlived its usefulness. Rather, it is a fundamentally important element of environmental governance, both at the EU level as well as the domestic level itself. It's important when discussing these issues that we don't actually shy away just from how challenging they are, but rather that we address them head on, that we consider reforms to how we implement the right of access to environmental information and how we actually achieve its aims, which in turn should, if it all works out in practice, lead to a much more effective means of improving environmental governance and acting to improve the environment we both live in and we rely on. So this then concludes our presentation and our lecture. I hope you all really enjoyed it. We've got our Q&A session coming up now. If you've got any easy questions, do ask them to me. And if you've got any hard, difficult questions, please ask Colin them. Thank you very much.